Clerk will call the roll.
Glenn Whitley, County Judge.
Here.
Roy Charles Brooks, Commissioner Precinct 1.
Present.
Andy H. Wynn, Commissioner Precinct 2.
Here.
Gary Fickus, Commissioner Precinct 3. J.D. Johnson, Commissioner Precinct 4.
Here.
Constitutes a quorum.
Thank you. Our invocation this morning will be delivered by Pastor Todd Hertzberger from the Bethesda Community Church in Fort Worth. After the invocation, please remain standing for our pledges. Pastor, thank you for coming out today.
Thank you, Pastor.
Let's bow our heads and pray. Father God, we thank you for this day. Lord, we ask that you bless this gathering today, this meeting, Lord. We seek your guidance and your direction and your will in every business transaction that takes place every single day. We're thankful for all the leadership that you have established for this great county, and we ask you to bless them, bless this time together, Lord. Let your wisdom flow, and we just thank you for the many blessings that are upon this county, and also as the days and weeks, months, years to come, we just thank you that you're blessing it, and we give you all the glory in everything we do. We pray this in the wonderful name of Jesus. Amen.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Honor the Texas flag. I pledge allegiance to thee, Texas, one state, under God, one and indivisible. Mr. Manius.
Thank you, Your Honor. Members of the court, we have several announcements for you this morning, one dealing with the agenda and then one general announcement. On the agenda, under the administrators section, under 9A1, this concerns the prohibition against outside burning within the unincorporated areas of Tarrant County. Upon the advice of Randy, the Rainmaker Renoir, we are going to ask that we hold that at least for this week.
Yeah, I think we
And
could.
in fact, it's interesting. I haven't seen Randy in 2 days, and but he did let us
I
know.
think he's out taking care of the flash flooding.
Yeah, so anyway, so we're going to hold that particular item. The second item is that just to remind the court that next Tuesday, the 23rd, that we do not have court that day. And so our next court will be on the 30th of this month. And then also, Your Honor, I imagine you might want to make a comment, too, about the events that are going to begin starting Friday here in Tarrant County.
We've got a number of folks coming into town, a little over 2,200 now, I believe. So we're excited. We're bringing folks from county government from really all over the country. Will be represented here, and we've got a full schedule of workshops as well as our steering committees for our legislative. All of that's going to be taken care of. We got just an awful lot going on, and the weather has cooperated, and so instead of it being 105, I'm hopeful that it'll be around 95, and I just want to thank everyone who's helped and who's volunteered to help us with this over the next week. And that a deal. And again, if you've got any questions, holler at either myself or certainly anybody in my office, Jim Duff, GK. Their offices have been very, very helpful as we've gone through, as have all of your folks in their efforts. So we're excited. We're going to show them a big show, and we'll look forward to the next 7 days. Thank y'all.
Thank
you. Court members, you have before you the minutes of our regular meeting of July the 9th.
Move approval.
Second.
We have a motion to second. Any discussion? Please vote. Motion passes unanimously. We have a couple of proclamations or resolutions today. Commissioner Brooks, I believe you have one.
Yes, indeed. It is a pleasure as a part of our ongoing efforts to recognize young men who have achieved the rank of Eagle Scout, to recognize one such outstanding young man today. And, Your Honor, with your permission, I'd like to read the resolution of commendation into the record. For Eagle Scout Brandon Xavier Salone. Whereas Brandon Xavier Salone demonstrates dedication and commitment through his many accomplishments, especially in achieving the rank of Eagle Scout from Troop 528, Longhorn Council, Boy Scouts of America. And whereas Brandon is most proud of his accomplishment on his Eagle Scout project, where he and his team recruited volunteers and installed a xeriscape garden made up of Texas native plants that require little or no watering at the Texas Parks and Wildlife offices at the Joe Pool Lake Levee Traffic Circle in Grand Prairie, Texas. And whereas Brandon has successfully completed over 200 hours of volunteer service in the community, worked concessions at the ballpark in Arlington in support of the Southwest High School Band Boosters, participated on the City of Fort Worth Recycling Green Team during the concerts in the gardens, completed numerous community projects such as cleaning up the grounds of the Cowboys of Color Museum, and bussed tables and served meals at the Union Gospel Mission with the Shiloh Missionary Baptist Church youth. And whereas Brandon will be attending the University of Houston, where he will pursue a degree in civil and environmental engineering. And whereas this community looks with pride upon the outstanding example of leadership and duty that he has set for young people throughout Tarrant County. Now, therefore, be it resolved that we, the Commissioners Court of Tarrant County, are pleased to commend an outstanding young citizen of our county, Eagle Scout Brandon Xavier Salone, Troop 528, Longhorn Council, Boy Scouts of America, and congratulate him upon receiving the rank of Eagle Scout on July 27, 2013. In witness whereof we have hereunto set our hands and caused the seal of Tarrant County to be affixed this 16th day of July 2013. And for such an outstanding young man, of whom we are greatly proud, I move approval of this resolution of commendation.
We have a motion and a second. Please vote. Motion passes unanimously. Congratulations, sir. Come on forward and. We seem to be without the plaque.
Without a plaque. I don't know where it is.
Stall.
Should have been here. Yes, it should have. But, Brandon, congratulations. Thank you. This community is very proud of you and your accomplishments, and we stand ready to support you in all of your future endeavors. Please have a word, and we'll find that plaque. So your mom.
They're running right now, so just.
Please have a few words.
Well, before I wasn't going to say very much, but now I have to stall.
No, the plaque's here.
Never mind.
Now you can get a picture with the plaque.
Let's do it again.
Now, it's a
Good morning.
Good morning,
Morning.
Brandon.
First, I'd like to thank the Commissioners Court, especially Commissioner Brooks, for this honor. I'm with Troop 528, as he mentioned, and we are chartered by Shiloh Missionary Baptist Church, where Reverend A.E. Chu has been our pastor for over 50 years. I would like to thank my Scoutmaster, Tony Lampkin, and my troop for all their support, part of which troop is behind me to my left. I would also
Gentlemen,
like
would
to
you stand? Go ahead, Brandon.
I would also like to thank our troop sponsor, Mr. George Shin. I would like to thank my mother and father, and most of all, I would like to thank God. Once again, I appreciate this honor, and if there's anything I could say to those after me, actually not just those after me, to everyone, it's to not give up even when it seems impossible, because when it seems impossible, that's when a miracle is about to happen. Thank you.
Thank you, brother.
I'd like to ask Mrs. Salone to stand. You've raised an outstanding son.
Thank you very much. Thank you all for being here.
Thank you.
Congratulations again, Brandon. Next, we're going to have a recognition of our employees who've earned degrees using our county tuition program. And at this time, I'm going to call on Larry Wilson to come forward and recognize these folks.
Well, as you may recall, we started this program back in 1998, and since then, over 600 employees have taken advantage of the tuition reimbursement program, and thank you, commissioners, for keeping it going all these years. And we started recognizing people in court beginning in 2008, and we have so far recognized 81 employees. We're going to add 50% more to that today. As we have 43 people who have completed degrees during the past 18 months. So I'm going to call their names and by degree and ask them to stand and be recognized at this time. Those who earned associate degrees: James Castillo, IT. Debbie Connor, Domestic Relations. All of them will not be able to be here today. And by the way, I do almost all of this communication with them electronically, and unless I meet them on some other context, I don't know who they are. Crystal Gerald, JP Precinct 3. Priscilla Smith, Public Health. All those are associate degrees. Thank you. Bachelor's degrees: Sharon Boson, CSCD. Joshua Underwood, District Clerk. Lena Brazil, Human Resources. Christopher Kemp, CSCD. Kara Hokestra, Budget and Risk Management. She graduated cum laude. Janice Daniels, District Attorney. Brittany Drake, County Clerk. Carly Jones, District Attorney. Michelle Walter, Sheriff, Criminal Courts. Deanne Kahn, IT. Brittany Miller, Tax Assessor. Sharon Jones, Public Health. Jose Aguilar, Public Health. Leamber Hicks, CSCD. That's all the bachelor's degrees, and I will tell you that those names that I called in associate and bachelor's already are in pursuit of the next degree. So thank you all. We have 2 people who have earned their law degrees. Angel Williams, Juvenile Services. Sergeant Lee Sarles, Sheriff. Master's degrees, Bernice Mack, Juvenile Services. Shelley Alexander, Juvenile Services. Tina Glenn, Human Resources. Okay. Denise Hallmark, Domestic Relations. Whitney Thorpe, Public Health. Patricia James, CSCD. Ursula Nelson, CSCD. Peggy Campos, Juvenile Services. Patricia Cruz, Housing. Kamisha Bailey, Housing. Sarita Esquerda, Juvenile Services. Sherilyn Tucker, CSCD. Robin Cooley, Public Health. Roy Allen, Juvenile Services. Jacinto Ramos, Juvenile Services. And that completes the master's degree. Now, I did a survey because I often don't know when these people complete degrees unless they say, it's my last class, or they specifically tell me. So I did a survey to make sure that we didn't miss anyone, and I found that there were a number of employees who completed degrees on their own without assistance from tuition reimbursement, and I want to recognize those people today as well. And those are Hoa Pham, Sheriff. Pamela Smith, Sheriff. Those are associate degrees. Bachelor's degrees. I'll need help with this one, Judge.
Yeah,
Person, Madrid Aravena, Sheriff. Bruce Snyder, Public Health. Master's degree, Charlie Acomas, Sheriff. Tanisha Kennard, Criminal Court Support. Laura McKnight, CSCD. Stuart Siegel, CSCD. And Charlie Acomas also earned a doctorate, so he's not here, but...
And Larry, I also got another, John Ray with the Sheriff's
John Ray.
Department.
Okay.
Also within the past couple of months. Is John here? John.
All right, very good. Thank you. All right, for those of you who are present, we're going to convene briefly out in the hallway here for a group photo op, and thank you very much.
Just a second.
Oh, yes.
To those who received degrees in law, I trust you got them from Texas Wesleyan? Go Rams. Not yet. Not yet.
Thank you all very much. Again, congratulations for your hard work, and I know y'all did work very hard for that. So. And I would move that we receive and file.
Second.
We have a motion to receive and file a recognition of employees. Please vote. Motion passes unanimously. Court members, you have before you our consent agenda.
Move approval.
Second.
We have a motion and a second to approve the consent agenda. Any discussion? Please vote. Motion passes unanimously. We have a couple of public hearings this morning. There we go. Take off.
We need to open the public hearing for public comment and ask if there's anyone here that wants to address possible changes in the regulations.
Well, you'll tell us what you're talking about, then I'll open the public hearing.
Sure. Back in 1988, Tarrant County approved some licensing and permitting restrictions for automotive wrecking and salvage yards and junkyards. Since that time, the law has been changed with regard to several things, and so we changed, have some proposed ordinance changes. I call it ordinance because the statute calls it ordinance. I would not call it ordinance but for the fact that the statutes call it that. If you turn to 5, I don't know if y'all, I think we tried to get everyone what we had.
It's in your red folder also.
Okay.
As is often the case with ordinances, it's easier to explain it by starting at the last page as opposed to the first. And I don't know why that is, but that's the way it is. If you go to page 5, the last page, screening requirements. Under the old law, screening requirements could have been natural plantings, fencing, and only on those parts that faced public roadways or faced houses. The statute was changed and authorized basically what you see in screening requirements. That would be number 8 of page 5. 8 feet high is still standard, but solid barrier fencing is around all sides of the ordinance, around all sides of the junkyard and the automotive working salvage yard.
Do those existing salvage yards get grandfather clause on this, or do they have to
That's
go back?
why I wanted to go to this first. That's earlier, and that is somewhat grandfathered, if I get to that part in just a moment. In fact, we'll go there just right after we do the other one. The other one is punishment. That's number 9. In the old statute, it said Class C misdemeanors, but they changed it to this, a specific fine of 100, but not more than 500.
Each
all right.
day.
Each day. Now, let's talk about grandfathering and things like that. That's page 2. There's some exceptions for licensing. Basically, if you were licensed before today, lawfully licensed under the previous regulation, then you would be licensed. You'd have to get a renewal, and there's going to be an increased fee for renewal. And so that's that one under 2. Under 3, screening. Basically, we said you're exempt from these screening requirements if you were in operation prior to and lawfully licensed before. There are other ways to do this. I'm not going to say this is the only way to do it. That is just one way, and that's what we put in there. You will also notice in screening, one of the reasons we changed the statute is in our ordinance had, our old ordinance had references to the revised civil statutes. If you see in Roman numeral 3, A, B, and C, those are all referenced to the Texas Transportation Code, which was later adopted, and these, so we've made those changes too. Those sort of modest changes occurred as well. If you turn to page 3, there is currently the permitting fee for this is, I believe, $25. The ordinance proposes to go to $150 because the statute authorizes $150, number 1, and because I suspect we may be doing a bit more of this work than we have been doing up until now, but I could be wrong about that. Renewals are $150. We also put some other things in here in Roman numeral 5. None of the stuff in C and D appear, and maybe even E appear in the old ordinance, mostly because of we have learned things that we need to do, things that we think we need to accomplish with these folks so that we get a complete application at the time they give us the $150, and we don't have going back and forth between them on stuff like that. And that's one of the things that's a lot of this stuff is really to address what has happened over the years. If we don't approve it within 45 days, then they get the license. That may be somewhat controversial, but I think that actually works well for us because that puts the pressure on us to do it, and it puts the pressure on us if they have not completed an application appropriately or have never submitted correct paperwork, that we just go, it's denied. instead of having kind of a perpetual back and forth on trying to get them in compliance with it. And so that's what the changes are. And
Okay. At this time, then, I will open the public hearing and ask if there's anyone here wishing to speak to this matter. There appearing none, then I will close the public hearing and ask for any questions from anybody on the court.
I've got a comment, and that is that this is extremely timely for Precinct 1 because over the past 2 to 3 months, I've gotten perhaps 100 emails from residents out in the unincorporated area in response to a sign that has been placed on a fence saying auto salvage yard coming soon. So to the extent that this gives us additional authority to regulate that kind of use, I think it is welcome.
We need to take
We'll
action
see.
today.
I think we can take action today, and so if the court would choose to, then
I move approval.
Second.
we have a motion and a second. Is there any further discussion? Please vote. Motion passes unanimously.
thank you.
Thank you. Our next public hearing is to consider our second amendment to the Program Year 2011 Action Plan for Community Development. Ms. Ward?
Good morning. We're requesting, the court to reallocate $413,691 from housing rehabilitation to CHODO set aside for acquisition, rehabilitation, and new construction. We need to spend the money out a little bit faster, and this will allow us to do that. So,
At this time, I will open the public hearing and ask if there's anyone here wishing to speak to this matter. Appearing to be none, then I will close the public hearing and ask if anyone in the court has any questions or action at this time.
I would move approval.
Second.
We have a motion and a second. Any further discussion? Please vote. Motion passes unanimously.
Thank you.
Thank you. Mr. Manius.
Thank you, Your Honor. Members of the court, we have several items to bring to you this morning. The first item, we're requesting that the Commissioners' Court adopt Amendment Number 1 to the Interlocal Cooperative Reimbursement Agreement between Tarrant County and the Texas Commission on Environmental Quality.
Move for approval.
Second.
We have a motion and a second. Any discussion? Please vote. Motion passes unanimously.
Members of the court, if we could go to item number 3, we're requesting that the court approve a lease agreement between Tarrant County and the Auto Crimes Task Force for space located at the Resource Connection.
Move approval.
Second.
We have a motion and a second. Any discussion? Please vote. Motion passes unanimously.
Members of the court, if we could go to item number 4, we're requesting that the court concur with actions of the Hospital District Board of Managers and approve a commercial lease which is located at 200 West Magnolia Street between the Hospital District and Westmont Properties.
Move for approval.
Second.
We have a motion and a second. Any discussion? Please vote. Motion passes unanimously.
Members of the court, on item number 5, we're again requesting that the Commissioners' Court concur with actions of the Hospital District Board of Managers and approve a commercial contract for improved property and office lease agreement. This is at 710 West Luda in Fort Worth, and the subsequent lease back to the seller of property, which is also located at that location.
Move approval.
Second.
We have a motion and a second. This item, as well as in that last item, both kind of circle around or center around the 1115 waiver, some of the 1115 waiver projects that we've gone into. So, any further discussion or comment? Please vote. Motion passes unanimously.
Members of the court, if we could now go to item number 6. This concerns a receive and file of the county administrator's report as it relates to the Rendon Bloodworth Road project, which is located in Precinct 1. And before I make a presentation on this, Your Honor, I would respectfully request that once action is taken on this particular item, the county auditor also has a report as it relates to this, and she would like to make that report as right behind my report.
Okay.
Members of the court, if we could go to that item, then let me very briefly touch on this, and then I'll try to answer any questions that you might have. This was a request by Commissioner Brooks to look at an issue dealing with the intersection of Farm to Market Road 1187 and Rendon Bloodworth Road. When we were first asked to do this analysis, we automatically asked other departments to participate in this, and those departments included the county auditor's office, the district attorney's office, and the purchasing department, along with our own transportation department and Precinct 1. Somewhat of a history, you might recall that we have taken various actions as it relates to this particular location back in 2008 and 2009 because of the hazard that was created by that particular intersection. There was a belief that we needed to do something to diminish the hazard-related activities and improve safety as it relates to that intersection. In fact, the court, through various orders, ordered that we acquire right-of-way that would allow us to build a cul-de-sac at the end of, or at the intersection of Rendon Bloodworth Road, and then we took action to close that particular road. That road had had many serious accidents, some fatality accidents, and this court believed that that was the process that was needed to at least increase the safety at that intersection. We did those particular actions, and the report indicates the court orders that dealt with those particular actions. When we closed Rendon Bloodworth, it actually caused a negative impact, if you will, for the residents and at least one business that was located at that particular intersection. There was a business that was known as, or that is known as JY Mobile Home Sales. It's located specifically on both Rendon Bloodworth and also on FM 1187. There was also a residence, the residence of Gerald and Julie Manning. Basically, they had two entrances to their property, one on 1187 and one on Rendon Bloodworth. They had consistently utilized Rendon Bloodworth because it was a much safer entrance into their property. And so when we closed that road, especially when they were traveling on 1187, they would exit 1187 to turn onto Rendon Bloodworth and then enter their driveways. When we closed that intersection, it no longer allowed them to do that. With JY Mobile Homes, this was, first of all, their business is they move large mobile homes in and out of that property. And the way that the intersection was constructed and how they did their business, their main entry was off of Rendon Bloodworth. And they would take Rendon Bloodworth, and that would be the access that they would have into 1187. With the closing of that intersection, they could no longer utilize that road to access 1187. So we had at least two areas that we needed to deal with, that being the JY property and also the Manning property. As it relates to the JY property, county personnel working with TxDOT came to the conclusion that we could partially make, or at least attempt to make JY Mobile Home whole by constructing a new entrance onto FM 1187. This would be something where that it would be big enough so that he could, or that company could move their trailer homes onto 1187 and actually conduct their business. The activities that we did by closing that intersection basically almost, well, it did. It negatively impacted the business to the point that the person could not do any more business at that location. So there was a belief that by building this access directly onto 1187 that it would allow JY to go ahead and continue to perform their business as they had before. JY agreed to that. The Transportation Department drew the plans, TxDOT approved the plans, and basically what was constructed was a driveway that was a little over 56 feet long and 45 feet wide. So it was a large driveway, and it would have to be in order to allow those mobile homes to come in and out of 1187 in that property. The problem with that intersection was that if you look at the terrain that's at that intersection, or that S curve now, there was a deep ditch that existed from, and it was a curved ditch that we had to cross in order to build that driveway. And so what the plans call for was to construct or to lay two 36-inch box culverts in that ditch, connect circular concrete culverts, 36-inch, to those at an angle, which is very important, at an angle, so that it would not restrict the water flow of that ditch. And then to finally, at the ends of each of those RCPs, to install a safety end treatment, which is a triangular type box, and it allows so that if there's any type of accident where someone runs off the road, that they would not run directly into a 90-degree type RCP, but it would allow them to simply have much more safer outcome if there was an accident. The plans were drawn by Transportation, and they were approved by TxDOT. And on those plans, it showed that driveway, at least 20 some odd feet, about 20 to 22 feet of that driveway, would have to be constructed on private property. And this was something that TxDOT had required that we do in order to tie that large driveway into the JY property. As I said, TxDOT approved those particular plans, and we agreed to build that particular driveway. There were at least two meetings as it relates to that driveway. The first meeting was held on April 30th of 2012. This was a pre-bid meeting. It was attended by members of the Transportation Department, Precinct 1 Transportation, TxDOT, and at least two vendors that were potential bidders on this particular item. Purchasing Department was also there. In fact, the various meetings that I'm going to talk about, purchasing was in attendance at those meetings also. The project was discussed, and at the conclusion of that project, we determined that of those two vendors, one did not qualify for our vendor list, and the second one because of timing issues. And there was a desire both by the county and by the state to accelerate that construction because of the danger plus the hardship that we had imposed on JY. That because of that time frame, one of the vendors could not perform in that time frame. Therefore, the Precinct 1 and Purchasing contacted R.D. Howard Construction, and who is on our approved vendor list. The Howard Construction gave us a price to be part of that work, and that work included the laying of the sets, the safety end treatments. It included the construction of collars that would tie the box culverts into the RCPs, and then to lay the concrete across the drive. There was another meeting that was held on May 24th. At that particular meeting, R.D. Howard's company was there. Howard's company was not at the April 30th meeting. And at the 24th meeting, though the plans had been approved by TxDOT, or drawn by our county transportation department and approved by TxDOT, on the 24th meeting, TxDOT believed that there needed to be some changes in those plans. Things from including dowels into the box culverts to some additional bent steel, some additional concrete that needed to be poured between the two SETs on both sides. And one of the major things that occurred was that on that meeting, the box culverts and the RCPs were already in place. But because of the curvature and to keep the water flow where it needed to be, there was at least a 30-inch distance between the box culverts and the RCPs. And this was not denoted on the plans. This was the first time Mr. Howard had seen those, and that's where the collar needed to fit. Basically, it was to connect those round RCPs to the square box culverts. And as additional changes were being requested by TxDOT, during that meeting, Mr. Howard basically said, you know, for the price that I bid, I can't perform this work because you're extending or you're increasing the scope of the work. You know, it wasn't made clear to me that the box culverts and the RCPs were that far apart. It takes more concrete, more and how you build those collars. And the Howard Construction basically said we can't perform that work as it relates to the bid that we gave you. One of the things that was also noted at that time was that Mr. Howard stated that he had already put in the order for the SETs, those that were precast, and that it would take 3 to 4 weeks in order to deliver the SETs. During the SETs, safety and treatments. At that point, because the county and wanted to expedite this process, there was a belief that we could go to a different vendor that had the SETs in stock so that we wouldn't have to wait 3 to 4 weeks. And Howard Construction basically stated that if we don't have to do the SETs, then we can perform all this other work and stay within the price of our original bid. It was verbally agreed to at that time. Howard Construction went back at the end of the day, submitted the changes, the adds and the deletes to Precinct 1 in an email that was dated the 24th of May. On the 25th of May, Precinct 1, through its Director of Field Operations, Mr. Webster, sent an email back to Howard Construction that stated, this is your official notice to begin work on the project. So we agreed to those changes, and we gave the order to proceed. The work was completed, and the driveway was built. On the Manning property is more toward the east on that curve. It's an S curve. But the bar, or not the bar ditch, but the ditch itself was on 1187 was still a pretty deep ditch. Deep ditch.
We hear you.
Deep ditch.
You don't
We
know
hear you, but we also understand what you're trying to say.
Thank you very much, because I'm trying to figure that out myself, Judge. Thank you. The driveway for the Mannings that was on 1187 was a fairly narrow driveway. It was probably 8 to 10 feet. And because of the speed as it related to that S curve, it would be very difficult to safely turn into that driveway. Additionally, the post office and the postal delivery man used to deliver the mail on 1187, on Rendon Bloodworth, but because we closed that intersection, the Postal Service requested that we move that mailbox, or that mailbox be moved to 1187. There had to be some type of a safety built so that the Postal Service could pull off, deliver the mail without getting hit. And that was done. In fact, in order to make sure that there was not only safety for the Postal Service, but also for a deceleration lane for the Mannings to basically pull off of 1187 into that driveway, both TxDOT and the county agreed that we needed to construct some type of deceleration lane. And so what happened was that the ditch was deep. We installed an 18-inch RCP because there was an 18-inch RCP running under the current drive. We put an extension to it.
RCP.
Which is the circular concrete pipe. Okay? We extended that. We put a safety end treatment on that end also. It's a smaller one. Because it was only an 18-inch pipe. And then we paved over that to enlarge that entry. That basically took care of the Postal Service. But there was still an issue dealing with the deceleration aspect. And talking with TxDOT and with our people, there was a belief that we needed to build that deceleration light. So there was a concrete pad that was constructed starting at the right-of-way line and extending into the Manning property. And that piece of work was done on private property, not within the right-of-way. And so the work was completed. Mr. Howard's company received a purchase order from the county to do that extra piece of concrete work, and I believe that cost was $5,775. So the work was completed, and to the satisfaction of the two landowners, and they were made whole. We were asked to look at the process by which this was done and to determine if there were any findings or as it relates to that. We did do that, and we have 4 findings, and these are those findings. First, let me say that this project was much more complicated than the majority of the type of road work that the county does. When I say that it was more complicated, it was, first of all, we closed a county road. Second of all, we built a cul-de-sac at the end of that. We bought right away and built a cul-de-sac on the end of that road. Because that road intersected with a highway that was owned by the state, and because we had negatively impacted at least two groups, both the JY and also the Mannings, we had to make them whole. So the construction that we did as it relates to JY was actually on a state highway. And the majority of that driveway was on the public right-of-way. Though that driveway was 56 feet long, about 20 to 24 feet of that was not on public right-of-way. Now, we had secured the right of access from both Manning and JY to go on the property to do the work. However, we did not secure the right-of-way as related to the work on a part of both of those projects, or those elements of this project. It was extremely difficult to do this analysis because the data that was needed, or a complete picture of this, was not located in any one location. So here are our findings. The first is that there was no centralized project file that contained all the necessary paperwork as related to this project. There was not one place that we could go to find all the relevant documents as related to this project. Purchasing had the POs. Audit department had POs plus the payments. Transportation had the blueprints. Precinct 1 had the field paperwork. There were emails that were utilized that were not found in any file. And so it took us a while to do this analysis, and we wanted to do it thoroughly. We believe that if you have projects of this nature, this complexity, not all in the majority of your projects do not have that complexity, but this was a complex issue, that there needed to be some type of a central project file where the paperwork and documentation could be located. Changes were made in the project scope. Justification relating to the charges and other project issues were not fully documented. And as I said, while routine projects are not this complex, this project, particular one, was. The second finding is that there needs to be a more centralized or more focused and formalized process by which significant change orders are justified, approved, and documented. While the change orders were approved, there was not as much costing that we believe that should have occurred as it relates to those change orders. However, what we did find was that they were approved by county personnel. The third finding, and this deals with the R.D. Howard construction. The changes to that purchase order were approved by Precinct 1, and a formal notice to proceed was also issued by the county personnel. There's been much discussion concerning the elimination of the SETs in the purchase order. However, there's document which exists that changed the purchase order, the agreement to do additional work, and then the acceptance of the price and the notice to proceed. And then finally, the county performed some work on private property that was not on the public, that was not within the public right-of-way. On both JY and Manning, we obtained this temporary easement to do the work, but we didn't secure the necessary temporary right-of-way in order to do that particular type of work. We could have done this. There is the ability of the Commissioner's Court to look at projects like this, especially whenever we take some type of action that causes either one or more parties to be, I want to use the word injured, but to be impacted negatively, where that we could have come into court, declared a public necessity, justified that necessity because of the safety and access requirements, and we could have gained, we believe that we could have gained the temporary right-of-way necessary to do the work. So those are our findings. As I said, this is somewhat of an unusual project for Tarrant County, and I've explained why. I will say that both the JY and the Manning property owners were made whole as a result of the closure of the roadway, and both of those parties are satisfied with what occurred, and so we don't believe that there's any additional work that needs to be done. Of course, we want to thank all the various departments that assisted us: County Audit, District Attorney's Office, Purchasing, Central Transportation. Commissioner Brooks, your people fully participated in this effort. Members of the Court, we are ready we stand ready to answer any questions that you may have as it relates to this report.
Do you want to hear the report from the auditor before we?
Yes.
Why don't we go ahead and have Renee come up, give her report, and then if there's any questions at that point in time, we can have those.
Good morning.
Good morning.
Good morning, Renee.
Our review was primarily over the controls and the financial processes related to this project. As Mr. Manius pointed out, I feel compelled to note in the report and stay here today that we found no evidence of wrongdoing, duplicate, or improper payments by the vendor, to the vendor, or by county personnel. We do have a number of recommendations, though, that we feel would make this process a better process for the county. As Mr. Manius pointed out, there were changes in scope on the project. Those changes in scope were not documented. The vendor sent an email, which the county accepted as documentation for the changes. There were deducts, there were additions. Speaking, we have problems today. The SETs, or the sloping in treatments, were the point of focus by everyone. Originally, the contractor was to provide the SETs. The county agreed to provide those, as Mr. Manius explained, for various reasons. The costing of what we received for what we traded off for what we provided was never adequately documented, and if it was performed, there is no evidence of that. There is no evidence that we asked the vendor to supply any cost related to that. There's no value. From my perspective, it is impossible today to determine whether there was adequate changing of the amounts between the work and the scope. It's not feasible. It would not be prudent to attempt to do so. In the future, though, we have some very specific recommendations. The first recommendation we have deals with when a requisition for road work or materials is entered or requested, that each and every one of them include a project number. The county was appropriate in all manner related to this project, and that all bidding laws were complied with. But in the future, to ensure that we continue to be able to meet those requirements, purchasing really does need to have the actual project number on all requisitions. We were buying materials and supplies for this project from various locations. We had a contractor providing pieces of the work, and again, we needed the same project number on all of the requisitions. We're also, of course, recommending that all changes made to services provided under either a purchase order or a contract should clearly be supplemented or a change order provided formally through purchasing. The purpose of the change should be clearly documented, the scope should be described, and any and all changes in cost associated with either the additions or deletions should be addressed. Furthermore, as we state in the report, as Mr. Manius pointed out, this project is not a normal road project that the county enters into. So from our perspective, any county work that is outside the normal scope of the day-to-day work of the road crews, including such work as working on TxDOT roadways or winding up needing to do work on private property, our recommendation is that first of all be required to be submitted to the administrator's office for review, and at that point in time, then a decision can be made whether or not it warrants being brought back to the full commissioner's court. It's just another check and balance that someone else is looking at the type of scope of the project before the road crew continues down that road. That is not for day-to-day or normal process. That's for the extraordinary or out of ordinary. And also, we would recommend that the county consider using the transportation department or some other firm or engineering type resource if you really need to price out these changes. If you're going to be doing a little bit larger projects like this, then you need someone who could maybe come in and help you evaluate the cost. Transportation would be our suggestion on that. And then finally, our other recommendation really deals with in our accounting system that we installed, we have what's called a three-way match. We have a purchase order, we get an invoice from the vendor, and when we get a goods receipt, we cut a check. So everybody that works at the county that's involved in entering goods receipts and determining whether or not those goods were received, those services were received, they're part of the payment process. There were instances we found where delivery tickets were not signed, so we had a hard time verifying who was responsible for actually, receipting in that merchandise, and then certainly the goods receipt was entered into SAP without the supporting documentation. All of the materials were received, all the materials were accepted, they were in good quality, but we're asking that the process be improved specifically in this instance, but also just making a comment to the county that it really is important that when you enter a goods receipt, if a clerical staff person is doing that based on a technical person's knowledge, we really need to make sure that the technical person has signed off and documented that we have those goods and that they're in good working order and good quality. So with that, that's our recommendations related to how we could improve this process.
Any questions at this time?
Of course, I've got a comment that I'd like to make, but before I make that comment, Renee, I'd like to emphasize a line from your report that you did not read into the record, so I'm going to do it myself. In response to the allegations made towards R.D. Howard Construction, we found no evidence of wrongdoing. I think that's important to clear the record. Now, I thank the county administrator and the auditor's office for their coordination of a thorough and comprehensive analysis of the facts surrounding the Rendon Bloodworth FM 1187 project. I am gratified by the auditor's finding that no duplicate or improper payments were made. I am also gratified that the auditor's analysis found no evidence of wrongdoing on the part of R.D. Howard Construction, one of Tarrant County's most successful minority businesses. As the administrator stated, this was a complicated project involving several county departments and a state agency. That, however, is no excuse for the shoddy record-keeping and lack of administrative controls cited by both reports. Those things end now. I have met with both Mr. Manias and Ms. Tidwell to make sure that I understand the deficiencies they found and the recommendations they made. Those recommendations will begin to be adopted immediately. We will implement all of the recommendations of the auditor and the county administrator. We will have greater transparency. We will redouble our efforts to protect taxpayers' dollars. And we have already taken steps to improve communications between the precinct garage and the commissioner's office. The mistakes made on this project were well-intentioned. Good intentions, however, must be balanced against proper procedure. This will not happen again. Thank you.
Any other comments or questions at this time?
I do have a question, Judge.
Okay.
I'm not sure who to direct this question to. Maybe Mr. Riley can help me with this. How did we conduct the public hearing before we decided to close the road? It seems peculiar to me how we have a major business and a private resident missed the information that we were supposed to let the public know. So can you explain to us, is there anything we can do to thoroughly notify the public before we make a drastic decision to close a roadway?
From what I understand, I was not employed by the county at the time, but from what the conversations I've had, we had signs out there denoting the closure of that road for several months prior to the closing of it, just to warn the public. I think the traffic coming off of 1187 and the traffic that was on Rendon Bloodworth also. But from my understanding, that's how we notified the public as far as closing that roadway.
So we had very visible, large signs.
From what I understand, yes.
Okay. And those two entities missed the information and did not participate in the public hearing before we made the decision to close the road.
I'm not sure of that myself.
We advertised the public hearing according to statutes. This public hearing was conducted in the Commissioner's courtroom. We went through all the appropriate processes as related to that closure, and I do not believe that we had anyone who came forward as it relates to that public hearing.
Okay. Because if those two entities knew about the closing of the road, and they came forward and expressed a concern prior to the decision and the execution of the decision, we wouldn't have these problems. Okay? So if there's any way, perhaps, that we can consider being a little bit more thorough in notifying the public, perhaps when we make a decision that has such a drastic impact to the residences and the businesses around that area, perhaps that we should consider sending out a notification to residences and businesses within a 1 or 2 mile radius, maybe. I'm not sure that's the right decision, but I have seen some other public entities done that.
I've taken notice in this process as far as in the review of it, and I think it would be beneficial to everybody involved to at least, to have a public meeting with affected property owners, mainly along the road where it affects them, and possibly in the near vicinity of the project, as far as a personal public meeting.
But I'm assuming at the point in time that we let this contract, we had communications with the landowners, and they were in agreement with what we were proposing.
They would have had to, because they signed the right of entries onto their property.
Okay, so
We were working with JY and also with the Mannings as related to this. So, for example, JY was aware and approved the driveway, the large driveway. So we had been working with the landowners on that particular issue. I spoke to Mr. Manning personally, and he was aware of the issue. First of all, it was the mailbox, and then the deceleration line. So they were familiar with that. And as you said, Judge, we did.
This was all done as a part of the closing of the road. Is that not correct?
It was through that process, yes.
Okay.
So I think we were working with them. I think the deal is exactly how, the changes that occurred as we got into the project.
Okay.
From that perspective. But I do think, and I do appreciate your looking at in the future, how do we make sure that we better communicate with those folks or with any affected folks along those processes. If there are no other questions at this time, then I would like for us to receive and file both reports.
Your Honor, if we could do those in two separate votes.
Yes. Each one will be done separately, but first the administrator's report and then secondly the auditor's report.
And if I can make only one other comment, my recommendations are not isolated to precinct 1. They're recommendations that the court consider for all precincts. So I just want to make sure that's clear. This situation, in my opinion, could occur in any precinct at any time, given the nature of whether or not we're clearly documenting and following. I'm not saying that we're not doing it in any other location, but I just want to make sure that everyone understands that our recommendations are for all precincts. We did not go out to any other precincts, but we would suggest that all precincts consider adopting our recommendations.
Just for the record, Precinct 2 last week conducted our own internal audit, if you will, of the procedure, and I'm happy to inform that Precinct 2 is in compliance with your findings, with your recommendation.
Move approval to receive and file the administrator's report.
Second.
We have a motion and a second to receive and file the administrator's report regarding the Rendon Bloodworth Road project in Precinct 1. Any discussion? Please vote. Motion passes unanimously.
Move approval to receive and file the auditor's report.
Second.
We have a motion and a second to receive and file the auditor's report. Are there any, is there any discussion at this time? Yes.
I'd like to just question the, furthermore, number 1, where you're recommending that anything outside the ordinary go through GK's office in all 4 precincts. Why GK's office and not the DA's office? They're the ones that normally make the legal rulings, and I don't think we need to overburden our administrator's office with reviewing every project that we do that might have a little twist in it.
The reason that the administrator's office was chosen was simply to provide an outside look into the aspect of whether or not it qualified as a project that was worthy of potentially being brought to the Commissioner's Court as a whole. Mr. Manius works closely with each of you and is responsible to you directly, so I looked at it as an extension of yourselves. It wasn't really a matter of legal issues. It was simply a matter of having Mr. Manius coordinate with your precinct folks if there were situations where, again, we were working for TxDOT or doing, again, projects that were not in the normal scope. So, again, he was chosen, and the word put in there that he review these because he is an extension of each of you. And he could then make a determination through discussions with your offices and with you yourselves on how best to proceed forward.
Well, that's a recommendation. It's not a policy of this court.
Yes, sir.
Okay.
Any other questions or discussion? Please vote. Motion passes unanimously.
Did you get a second to that motion?
Commissioner Williams.
I second.
Thank you.
Okay, moving on, Ms. Tidwell, you have a couple more items, I'll see.
The next item we have to ask the court's consideration in is receive and file the auditor's report related to the district clerk's registry of court accounts You have the report and the response attached.
Move to receive and file.
Second?
A motion is second. Any discussion? Please vote. Motion passes unanimously.
Next, we're asking that you receive and file the auditor's report of the tax office related to the motor vehicle bank reconciliation process.
Move to receive and file.
Second.
A motion is second. Any discussion? Please vote. Motion passes unanimously.
Receive and file the auditor's report related to the review of the Tarrant County Constable Precinct 7 property room.
Move to receive and file.
Second.
We have a motion and a second. Any discussion? Y'all been busy down there, haven't you?
We have.
Please vote. Motion passes unanimously.
And finally, we're asking for approval to release depository collateral of the $25 million as so depicted in your court communique.
Move approval.
Second?
A motion is second. Any discussion? Please vote. Motion passes unanimously. Thank you, Ms. Tidwell. Ms. Snyder?
Risk Management Board is recommending the payment to State Farm Insurance on behalf of subrogation of their client in the amount of $2,276.33.
Move approval.
Second.
A motion is second. Any discussion? Please vote. Motion passes unanimously. Ms. Glenn?
Move approval to receive and file the personnel agenda.
Second?
A motion is second. Receive and file personnel agenda. Any discussion? Please vote. Motion passes unanimously.
Thank you. We have 4 additional items for the court this morning. If we could skip to item 3, we'll come back to item 2. So with item 3, we're asking the court to approve organization changes to the sheriff's office and the county criminal court 1. Judge Hill is requesting that the court approve a transfer of a vacant bailiff's position to the sheriff's TO effective July 17th.
Move approval.
Second?
We have a motion is second. Any discussion? Please vote. Motion passes unanimously.
Item number 4, we're asking the court to approve changes to the table of organization to add a project employee in the county clerk's office. The county clerk is currently reviewing technology upgrades in the central library, and as such, is looking potentially at perhaps a reduction in staffing over the next year or two. But while this review is underway, rather than fill a vacant position, a pay grade 14 position, the county clerk is requesting the addition of a project position, which is a temporary position. This position will be funded from the Record Preservations Fund.
Move approval.
Second?
We have a motion is second. Any discussion? Please vote. Motion passes unanimously.
Item number 5, we're asking the court to approve a change to the table of organization to add 1 full-time court reporting position to County Criminal Court number 10. Judge Sorrells eliminated back in 2011 a full-time court reporter position and made a decision then that he was going to use substitute court reporters. Judge Sorrells is asking at this point to have his full-time position reinstated. He's indicated that he's concerned about the quality of the substitute services that he's received and believes that the court has suffered because of it. He's asking again for the reinstatement of his full-time position effective July 17th. The impact to the general fund is outlined in your court communique. We're looking at approximately $94,000, excluding fringe benefits. Of course, some of this will be offset by the $25,000 that's currently allocated for substitute services.
I don't have a tremendous problem with this, except that it seems like it may be more appropriate to consider during the budget process than now.
I would guess the question would be, why are we doing this now as opposed to at the end of the budget year and as we begin the new budget year?
I don't know that I have an answer for that. Do we have anyone from the judge's office here? Apparently not. I don't know the answer to that question.
Debbie, you've been through budget, I'm assuming, hearings with them?
Judge Soils himself was not available or did not attend that meeting. I can speculate on what my thoughts are regarding your question, but I'm going to keep that to myself because it's just speculation.
Okay. So,
And you know, some of the complexities, just the even playing ground here, some of the complexities that go along with operating without a court reporter, and let me mention there are several of them that do. Several other courts share a staff court reporter. One of them is the securing of evidence. All evidence that's presented during a trial becomes the property basically of the court reporter. Right now, Judge Soils is the one that has to hold on to that evidence and account for it. Now, what the long-term disposition of that evidence, I'm not going to pretend I know the answer to that sitting here today because I don't. Also, as far as scheduling court reporter, in the event there's a record requested by the party, by the defendant, then they have to find their notation of who actually was the official court reporter for that particular day and case. So there are some complexities. He has been pretty much working as a single incumbent in that court. He has a bailiff and himself. His court reporter was eliminated a year and a half ago, and his court coordinator position has been vacant for a while. He's in the process of hiring his coordinator right now. So he's been about as conservative as they come for a while.
Is it going to pose a huge problem if we make an exception?
I can't answer for him. I'm sorry. I did not specifically ask him that question. You mean if we wait until the budget cycle?
and I think what he's asking is if we go ahead and make an exception and go ahead and do this before the end of a budget cycle, is that going to create a problem for you or for the county?
No.
Because this, in effect, is a budget
It's a budget issue.
budget amendment during the current year.
And he does have savings.
But I guess I hear from what I'm hearing you saying is and this I guess a little bit surprises me. What you're saying is because the court reporter is responsible for the evidence, and because his are really contract court reporters, then he is the one responsible for the evidence, and the evidence must stay.
That's right.
Within his keeping. Okay, that does change a little bit.
And you know, basically, if we were considering this in the budget process, we would have included it. We would recommend.
So you are recommending it in next year's budget?
I tried
So-
to talk him out of it. I tried to talk about some offsetting situations, which some of those may still take place. But we talked the whole spectrum of pros and cons.
About the possibility of sharing as others?
Sharing, some other uses outside of the court system. I mean, I laid on the table that civil service hearings, we hire a court reporter. If yours is available, can we? And he said those are all good discussions that need to take place at a later time.
Okay.
So they're on the table. Now officially, because I've spoken about it.
I'm going to make a motion to approve this item simply because of the urgent, in my understanding, this is an urgent situation for the judge because he is solely responsible for the evidence while also conducting his business as a judge. So I deem this to be an urgent situation. So I'm willing to make a motion, but I want to make a very clear comment that it is very important for me personally that we follow the budgeting process, because when we make a financial decision, we have to understand the financial implication of that decision. And right now, we just don't have a whole lot of details supporting that decision. But because of the situation, I think, and with some of the comment Ms. Snyder just made, I think it would be budgetary included, right? I mean, we have the funding for this.
I'm not concerned about that.
Okay. So I'll make the motion to approve.
I will second the motion with the caveat that I don't see any urgency at all to this. He's lived with this situation for a year and a half. There are 4 months before the new fiscal year starts. I can understand his desire to have some relief, but I don't think it rises to the level of urgency. I would vote for it for other reasons other than urgency.
Can I make one more comment? And Ms. Glenn touched on this. There was one of the things we just discussed was the fact that the quality of the staff, the employees that are not employees, but the quality of the contractors that are available is getting slimmer and slimmer. As a matter of fact, one of the contract reporters that he had frequently used was recently hired by Juvenile, who has had an open position. We've got one other court.
So we can blame this on Juvenile.
Yeah, I guess you can. Some of it. And we've got one other court that has a vacancy, and they've been going through quite a few court reporters that are available, just using them on a rotating basis to get a feel.
Don't oversell it, Debbie.
Could we delay this for 1 week and let someone check with the judge to see what, if it is that urgent, or if we can wait until the new budget year?
And that's a challenge. I'm not sure how urgent the situation is, and the judge and his representatives are not here to speak.
I think if we've waited this long, I don't see the harm if the court wants to wait an additional week.
It'll be an additional.
Well, it
Or
actually
2
be
weeks.
2 weeks.
Yeah,
Yeah, and
That's true.
you know, we can do that. I don't see a problem with that. Or I mean, again, as I think Debbie indicated that, you know, he's been pretty conservative on this. This is 2 weeks in a row, isn't it, Mr. Wright? We're gonna put a little penalty on this little phone ringing here before. You thought you were gonna get out of here without anybody knowing that. You kind of delayed in getting up and walking out. He's been very conservative. I think if we've expressed our concerns and stuff along that lines. I think if we leave it to his discretion, and I mean, I don't care whether we put it off for 2 weeks or we go ahead and give him approval and then go forward. Would the preference be to wait, or?
I think the most compelling argument is that Debbie would have recommended it for the budget anyway.
Yeah, that's okay. Let's go ahead and vote. Motion passes unanimously.
Thank you. So we can go back to item 2.
Because I think that's going to be a little bit of a discussion.
It may be a
I'm
little
going
bit
to go
of a
ahead
discussion.
and ask for just a couple of minutes of a recess, and then we'll come back in for longer. everybody to kind of take their seats.
Yeah. I'm hoping Glenn gets this over with pretty quickly.
Ms. Glenn, if you would continue.
Thank you, Your Honor. So the remaining item that we have is item number 2. We're asking the court to approve the continued selection of Pacific Care as the insurance provider of the fully insured group retiree.
Hold on just a minute. I can't
Y'all
hear.
would please take yourself outside if you're going to. Thank you. Go ahead.
Thank you. So item number 2, we're asking the court to approve the continued selection of Pacific Care as the insurance provider of the fully insured group retiree Medicare-based medical plans and the contribution rates for funding for plan year 2014. So let me walk you through the information that you have. You have quite a few documents, and hopefully we can go through it in a fairly expeditious manner. So you have a communique and you have a couple of attachments. So let me make a couple of just overall comments before we get into the actual attachments. So the court's obviously aware that we're here, typically this time of the year, sometimes a little bit later, to talk about funding for our subsequent plan year. The court's aware our plan years begin on January 1st and run through December the 31st. So we're here today to talk specifically about our retirees, specifically those who are 65 and older, their group options, their choices, which are 2 medical plan choices, and then, of course, the last thing we'll talk about is funding, i.e. how much of that cost the county will assume and how much we want the retirees to assume. So we have 2 plans that we offer this group. Again, we're talking about retirees 65 and older. These are the 2 plans that we've offered for some period of time. We offer what we call a Medicare Advantage plan or a PMA plan, and we offer a Medicare Supplement plan. And it's sort of the acronym that we use in our world is PSS, and you'll see that on the documents that we look through. And again, just sort of a high-level differentiation between the 2. If you recall, the Medicare Advantage plan, if you can think of it in terms of an HMO plan, it works very much the same way. There is a network of providers that our retirees select from. So you see certain physicians who are in the network. You pay co-pays for services. You pay co-pays for prescription service. So that's the Medicare Advantage plan. The Medicare Supplement plan, there are no networks associated with this particular plan. The requirement simply for both plans is that the retiree and their dependents, if they have dependents, have Medicare Parts A and B, and with the supplemental plan then simply supplements what's not covered by Medicare's Part A and B. So in theory, what happens with the Medicare Supplement plan for those folks that participate on it is that they pay their premium, the premiums that the county charges. They pay their Medicare Part B premium. They pay dependents for dependents if they have dependents. And then all of their services are covered at 100%. So there are no co-pays for office visits. There are co-pays for prescription drugs, but none for office visits or inpatient hospital stays. So at a very high level, those are the differences. Now, sort of looming in the background, every year when we have these discussions, is what we call our GASB liability, and that's the liability associated with offering these benefit programs to our retirees. You all may recall that Diana and our benefits consultants, Towers Watson, they were here several weeks ago, had a PowerPoint presentation, and in that presentation mentioned that as of 2011, our GASB liability is estimated to be $355 million. What's important for the court to know is as we have this discussion today, according to Towers Watson, $229 million, or about 65% of the liability, of the GASB liability, can actually be attributed to this group, our group meaning the 65 and older retirees. So if the court wants to consider making an impact on GASB, if that's the court's desire, today, well, I say today, in 2014 and going forward, then we really need to focus on how we cost share with this group. And so as we get into options, you'll see the options that we've outlined for you and what impact they have on GASB. The two documents before the options, you have Exhibit A1 and you have Exhibit A2. And here what we've tried to illustrate for you, and we've included plan years 2006 through 2014. And what we're showing you on the two documents, A1 and A2, are total premiums for both plans. And you'll see it's sort of the column, sort of just right of center just a bit. So those are total premiums for the plan. And again, so just for example, so that we're all looking at the same thing, if you look at 2013, which is your second entry from the top, the total premiums, and this is the Medicare Advantage plan. This is, if we can call it an HMO plan, it works very much that way. So for that plan in 2013, the premium is $151.10, and that's a monthly premium. So for this year, for 2013, retirees who participate on this plan pay $61.66 per month. That's their part of the premium. And the county pays $89.44. So that's how we cost share. You'll see in the far right column, the census. We have 197 retirees who participate in this program. The last column that I'll mention, you see percentage change. And what we've tried to reflect here is that from year to year, what the actual percentage change is in total premium. And so you can see if you start at the bottom from 2006 and look up your column to 2014, you know, some years we've had fairly minimal increases. For example, from 2006 to 2007, there was a 1.2% increase in the total premium. Of course, this past year for 2014, we're looking at a 13.7% increase. So that's just sort of an illustration to show you where we are again in terms of premium and cost share. And again, this is the Medicare Advantage plan. So if you look at your next exhibit, that's A2. The columns mean the columns represent exactly the same kind of information. Obviously, the rates are different. This is the senior supplement plan. And again, this is the plan that supplements once you have your A and B in place. Then this plan comes along and picks up the balance of whatever costs there are. You can see that these premiums are significantly higher than the Medicare Advantage plan. You can see in 2013, again, the second entry from the top, the total premium is $460.62. The retiree pays $243.89 of that cost. The county's subsidy is $216.73, and you can see our census, 368 participants as of June 1st. Okay? And again, you can see the increases from year to year, or decrease in the case of 2012 for premium costs. So if you just sort of keep those things in mind, we may need to sort of thumb back or sort of go back to them periodically, but that's just sort of background information. So if you don't have questions about that, if we can go to Exhibit B1. So B1 is where we are providing you with some options for your consideration for 2014. So we'll start with the Medicare Advantage plan. Again, these are proposed options and rates effective 1/1 of 2014. Let's start with the very top entry. You'll see 2013. Again, that's where things are today. The total premium is $151.10. You see the county contribution. You see the retiree cost. In 2014, we know, because we've been told, that total premium will increase by 13.7%, and in dollars, that's $20.72. So that increase has to be absorbed somewhere. So the question is, who absorbs that and how much? So in option one, we're proposing, and Diana and the consultants talked about this when they were here, they defined it as a hard cap. And what a hard cap means is that we take a look at what the county's contribution is this year in 2013. That's $89.44. And so that's the contribution, not just in 2014 with the hard cap, but that's the contribution, if the court so desires, from 2014 forward. So that would be all that we would ever contribute. That would be where the county subsidy ends. And what that means, and I'm going to jump ahead a little bit, is that with the hard cap, according to Towers Watson's calculations, we can impact, and specifically we can reduce our GASB liability by $140 million with a hard cap. But again, that means that the county's contribution does not increase. So in 2015, if there's an increase, then that increase goes to the retirees. The county doesn't take on any additional subsidy. Okay? So that's what the hard cap is. Again, that's the biggest bang for the buck in terms of addressing the unfunded liability or GASB liability. Option 2 is what we call a soft cap. So the way that option 2 works is, again, you see the premium, the total premium for 2014 is $171.82. The soft cap says that effective 2014 and forward, that the county, in the way of a subsidy, will assume the lesser of the annual increase or 3%. So 3% would be the most that we would ever contribute from 2014 forward. So if we have an increase in 2015 of 1%, then we would assume a 1% subsidy. The county would. We would increase our subsidy by 1%. However, if it's 10%, then we would cap our subsidy at 3% on top of 2013. So you can see what that means. If the court is interested in option 2, that will mean that the county subsidy goes from $89.44 to $92.12. And you can see that the retiree cost then goes from $61.66 to $79.70.
So the 3% is, that 3% is the 3% based upon what the county's currently paying versus 3% of the total.
It's 3% on top of what the county's current subsidy is.
The 89.44 or the 89.44.
Okay, so that's the soft cap. Now, what the consultant has told us, what Towers Watson has told us, is that, again, with sort of GASB sort of always looming in the background, if the court were to consider this option, the soft caps option, and I want to be clear, we're not talking about just 2014, but we're talking about 2014 into the future, right? If that's the county's desire, then we're looking at reducing our liability by about $91 million.
And that comes primarily because of the fact that under the actuaries' assumptions, they're assuming medical increases of about 8 to 9% over the next couple of years, and then going forward, they're estimating a 5% increase from those times forward. And what we're looking at here is, since we're a little more than 50% of the total premium, the 3% means that we're paying a little bit more than, it's increasing. It would be saying that we're going to put 3% on a little bit more than whatever the actual.
And again, that's certainly, that's more flexible than the hard cap, because remember, with the hard cap,
We're not changing at all.
We're not changing our subsidy at all. So whatever we.
Ms. Glenn, I've got a question. As I understand it, the existing rate structure is based upon reducing the $354 million so-called unfunded liability over a 20-year period.
No, not with, that's not the case with this. This is not your unfunded liability in your pension, which we do amortize over a 20-year period. This is the unfunded liability for the health insurance.
Right. So that's option 2. And then option 3 We've taken a completely different approach, and we've simply said, if the county wants to cost share more generously, then, and again, this is just a recommendation, then we could actually, the county could cost share and assume 50% of the increase for 2014. We could certainly decide if that's something we want to do going forward or not at 50%. So the county then increases its, or takes 50% of the $20.72, and the retiree does the same. So that's option 3. So in this document, you have I guess, an orange chart in the middle of your page. You can see the cost, the estimated annual cost for providing this coverage is almost $500,000. And again, we have 197 of our retirees who are 65 and older who participate on this plan. The next exhibit, if the court doesn't have any questions, then will be Exhibit B2, and this is the senior supplement plan. And again, sort of the methodology is the same. Option 1 would be the hard cap. We would keep the county subsidy at 2013 rates, which is $216.73. So that, again, would be the subsidy for 2014 going forward. You can see the resulting increase to the retiree cost. It would go from $243.89 to $258.46. Option 2 is the soft cap. And you, again, can see the impact to the county as well as the impact to the retiree. Again, this is where we have the largest number of our retirees participating. I believe we have 368. And we estimate for 2014 an annual cost of about $2.5 million to provide this plan. And so what we're asking the court for today, if you feel like you're ready to make a decision one way or the other, if you want us to go back and look at other options, but we're asking for 2 things. We're asking for the renewal of Pacific Care as the provider for these plans, and then we're asking for your decision, if you have one today, with regard to option 1, 2, and 3. And I believe that you received some information from Mr. Manius regarding his recommendation with regard to these options. And his recommendation would be option 2, the soft cap, because again, that allows us to address the GASB liability, and it certainly continues to provide some level of subsidy to our retirees in 2014 and going forward.
Questions? Discussion?
With the information, if the court is ready, I'll make the motion to renew Pacific Care as the provider, and also select option 2 as the way moving forward.
Soft cap.
Soft cap. I think that is I believe that is a happy medium between controlling future unfunded liability
I'll second.
and offset certain cost for all retirees.
Have a motion and a second. Any other comments or discussion?
Yeah, I've got a comment. I will probably support option 2 as the lesser of evils in this. I don't believe in the accuracy of the assumptions made by these so-called actuarial scientists. I think they're no more than a shot in the dark. It's kind of voodoo economics. Nobody knows what's going to happen in the future, and to try to predict and base charges to our employees based upon an inexact science, I think, is just unconscionable. But unless the judge can get rid of Gatsby.
I've certainly tried. And I would, I don't disagree with what you're saying, Commissioner Brooks. I don't think the estimates necessarily are reasonable. And not so much that, they've got their reasons for the assumptions that they've got. I just don't believe in looking at it from the long term that they're realistic, and I think there's going to have to be some change made because we're not going to get to the numbers that they're estimating that we're going to get to in 30 or 40 or 50 years, which are the numbers which they actually have in their presentation, without there having to be some sort of a change. By the same token, my biggest argument is about having to record the liability at all, because on any given Tuesday, we could completely decide not to offer this at all. Now, I know that concerns and scares a lot of folks, but we could do that on any given Tuesday, and there is a big swing in here, and I do think that we've got to find some way to address the health care costs. We do, as Tarrant County, I think, do well by our retirees, by our employees, much better than a lot of other counties in this state and in this country, and I'm proud of that. And our employees have been, very diligent, and so I think we go forward with this, and I think we're going to look at this and continue to look at this. By placing this soft cap on there, it does affect the liability. Our actions in the future will then determine how much that continues to affect that liability. And I just think it's a good way. But there's other things that we're going to be addressing this year as we go forward into the future with our health care. And I think a big part of it is going to be based upon everybody taking some responsibility for the dollars they're spending. And there's not been, the individuals have not had as big a stake in that in the past as I hope they're going to have in the future. And we saw some information this week presented by United Healthcare. It says there's a lot of things we can do individually to be responsible for and to certainly help in controlling our cost. And so my hope is that as we go forward, people are going to take a more active role in that. It's some of the statistics are pretty amazing, and I hope that over the next month or so, we'll have somebody from United Healthcare come here and actually go through some of Tarrant County's results as it pertains to how we're managing and controlling our costs and what we could be doing a better job of. Because it's amazing how few people within our group of employees attribute to probably the extremely high percentage of the cost. Some of them, they're doing as good a job of managing it as they can. Others, I would say probably, and in that category of those numbers, and I don't want to cite the numbers because I'll cite the wrong ones, but United Healthcare has reached out or has attempted to reach out to a number of our employees and help them manage things that they have going on in their lives that could help control their costs, and they can't even get a return phone call. So there are some things that we need to, as a court, encourage folks to do to help us to better control the cost. So having said all that, I too am going to go with option 2 and as a place to start and to see how that works. And I think we're going to have to experiment a little bit as we go forward.
I want to echo what the judge is saying, because I've been appointed to serve on the benefit board, and at that new set of responsibility, I have seen a very scary trend in increasing in healthcare cost. And if we don't find a way to work together to control that cost, ultimately we will have to face with a dilemma of cutting benefits and compensation and maybe even positions. So either we take a proactive approach in working together collectively in control healthcare cost as well as other costs within the county, because we don't have an infinite amount of money. As much as we would like to, we don't. And so I just want to echo what the judge is saying. I have seen it for myself, and it's pretty scary. And it's time for us to really face reality and work together to control that cost. Otherwise, within the near future, we're going to have to make some tough decisions.
Please vote. Motion passes unanimously.
Thank you.
Thank you. Moving right along, Ms. Brewer. Just streaming through this agenda today, aren't we?
Tarrant County Public Health has one item for your approval today. This is for the Public Health Department to participate in the 2-year Centers for Disease Control and Prevention Public Health Apprentice Program. This is the second time that we've had an apprentice opportunity with our Adult Health Services Program, and it's the 4th time we've been asked to take on a specialist and done so.
Move approval.
Second.
We have a motion and a second. Any discussion? Please vote. Motion passes unanimously.
Thank you.
Mr. Beecham.
We have 2 items for your consideration this morning. Our first item is a bid award recommendation for bid 2013-084, signing a contract for inmate food trays for the Sheriff Department. A recommendation would be to award a per enterprise basis, awarding the primary and secondary vendors as shown in your court communique. We did receive a bid from a company called Jones Xylon that did not meet specifications in regards to stacking, and they were not considered.
Move for approval.
Second.
We have a motion and a second. Any discussion? Please vote. Motion passes unanimously.
Second and last item is a bid award recommendation for bid 2013-090. This is our annual contract for cold applied asphalt crack sealant for use in all precincts. Recommendation would be to award a pre-enterprise basis, awarding to Martin Asphalt Company.
Move for approval.
I'll second. Did we only get one bid?
Yes, sir. This is one of those where we've had one for many, many years, unfortunately.
We have a motion and a second. Any further discussion? Please vote. Motion passes unanimously.
Thank you.
Thank you, Jack. Sheriff's Department. Did I miss you, Randy?
Oh, Chief.
No? Go ahead, sir.
I'm here in the role of Program Director for the Auto Crimes Task Force. The courts have provided 7 trailers to the Auto Crimes Task Force through forfeiture. This is an item that would typically be on your consent agenda, but essentially all we're asking you to do is to accept these trailers so that we can auction them off.
Move approval.
Second.
We have a motion and a second. Any discussion? Please vote. Motion passes unanimously.
When is our next sale, Jack?
August 17th.
Of?
August 17th, 2013.
August?
Yes, sir.
Thank you.
Thank you. Come on down.
My apologies, I was a little premature there. But, members of the court, we have one item for your consideration. We are requesting your approval of a local project advance funding agreement with the Texas Department of Transportation related to improvements to Precinct Line Road. This project is included in our 2006 Transportation Bond Program.
Move approval.
Second.
We have a motion and a second. Any discussion? Is this the precinct line up near 114, or is this the precinct line down by Hurst?
It's down in the Hurst area.
Is that around that bridge at Trinity?
Yeah.
Okay. Any further discussion? Please vote. Motion passes unanimously.
Thank you.
Commissioner Brooks, I believe you have an interlocal agreement.
Yes, sir. I move approval of items 901 A through D.
Second.
We have a motion and a second. Any discussion? Please vote. Motion passes unanimously. Are there any appointments? There being none, then you have before you the claims, including the addendum.
Move approval of the claims, including the addendum.
Second.
We have a motion and a second to approve the claims, including the addendum. Please vote. Motion passes unanimously. Briefing items, Mr. Manius.
Thank you, Your Honor. We have 2 items for the court this morning. The first is the update on the West Nile virus
Dr. Curian is here to address the court at this time.
Good morning.
Good morning.
Good morning.
We have no new West Nile virus human cases or positive mosquito samples to report today. So this season, we continue to have one human case and two West Nile virus positive mosquito samples. To date, we have tested 1,798 mosquito samples, and 151 of them were tested last week. Based on the most recent data on the number of trap locations countywide, we have 162 traps currently. I would like to provide a clarification on the number of trap locations that was provided in the last briefings. My apologies, I had erroneously stated that there were 292 traps countywide last week, which in fact was 93. 292 is the cumulative counts of all the trap locations that have been sampled since the beginning of the season. As far as ground spraying efforts go, Town of Pantego completed the ground spraying last Tuesday, which was July 9th, in response to a positive mosquito sample. And two additional locations in the unincorporated area, both locations were in Precinct 3, were completed, the ground spraying efforts were completed in these two locations on July 11th, which was last Thursday. And this was in response to increasing Culex densities in the trap locations in these areas. The review of the post-spray data from these two locations is still pending. Statewide, we continue to have two human cases, one from Anderson, one from Tarrant, and 21 West Nile virus positive mosquito samples from 6 counties. So I want to end by saying, with the recent rains, we expect the Culex counts to go down initially before it increases. This is because the rainwater typically washes out the existing breeding sites, cleans out the storm drains, the clogged drains, or the culverts, etc. So, and Culex, and there's collection, leads to collection of fresh water, and Culex mosquitoes do not like to breed in fresh water. But as this water stands for a few days, it takes about 3 to 4 days, add to this the debris collection on organic matter collection, then the water becomes a perfect medium for the Culex mosquitoes to breed. So it's important to get out there in your backyards, in your neighborhoods, in your communities, look for the standing water and drain. We have listed the usual sources on our website. In addition, look for pet dishes that are left out. We are finding this during our environmental scopes. Pet dishes, boats that are parked in your backyard, especially boats that are not covered by the tarps, good medium for, or good sources for rainwater collection. And the other important or potential sources that we are finding in our jurisdiction, which is the unincorporated area, is the animal watering troughs, especially the horse troughs. Good potential for mosquito breeding, especially if they are not maintained well. So ideally, it's ideal to drain these troughs or change the water every 3 to 4 days. And if that's not practical, then look for larvae in them. And if you find them, go ahead and larvicide the water. You can put the BTI dunks, safe for horses. If you don't like BTI dunks in the troughs, you can even consider putting larviciding fish, the gambusian, the minnows. They're good medium too. So look for tiny, dark, wiggly things. These are the mosquito larvae in your animal watering troughs, and take care of them. Thank you for your time.
Dr. Curian, I've got a request.
Okay.
I've had a contact from a constituent who complains about Echo Lake, which is located in Echo Lake Park. It is a fairly large body of water, but it is a stagnant body of water. The claim is that it is a mosquito breeding ground. I have no way of knowing whether that's true or not. I'd like for you to take a look at it and determine whether there is any need to be concerned about Echo Lake.
We'll certainly take a look at it and work with the appropriate officials, authorities on this. I'll get back to you on that.
This is the only county park, and it's located in Precinct 1. So I suppose I would be the appropriate authority.
It is now.
It is now.
Thank you very much,
Thank you.
Doctor.
Finally, Your Honor, we have one additional item. It's the legislative update. Mr. Mendez is here to address the court at this time.
Good morning. I'll be very brief. The only thing left on the legislature's plate is the transportation issue. During the special session, the previous one, there was only one proposal before them. It got out of this House and died in the Senate with the filibuster, and that was diverting half of the money that goes into the rainy day fund towards transportation issues. The House has come up with a new proposal, which is what they debated last night, and that is to end the diversion from the gasoline tax, which 25% goes towards education, and putting all that money towards transportation, and replacing the 25% that went to education from the rainy day fund. So it's kind of an interesting proposal. They both raise about
It's a wash.
It's pretty much a wash. They both raise in the neighborhood of $1 billion a year. The House did pass that measure last night to third reading, but it requires 100 votes to get it before the voters as a constitutional amendment. They lack 8 votes. So they've got 2 days. The House is not going to meet again until Thursday. They've got 2 days to gather those votes. There were 24 absent members on the floor yesterday, so I think they have plenty of time to gather those votes.
You know who the 92 were?
Yes, we do.
Can you just give us a list?
Yes, I will. I will send that to the court. There were a few no votes from the Tarrant County delegation that we need to work on. County advocacy groups and transportation advocacy groups have stated no preference as to which of these issues makes it through and gets on the ballot. We just want the new money for transportation, and that has been our message to date. So we'll get to work on that, and I'll get you all the information.
Thank you.
Yes, sir.
That's all we have at this time, Your Honor.
And at this time, we'll recess from our open meeting and proceed.
We have a request.
Oh, we do have that. Okay, excuse me. Mr. Howard, please give your name and your address.
My name is Randall Howard. My address is 3863 South Freeway, Fort Worth, Texas, 76110. County Judge, Commissioners, everyone, I have just some thank yous as well as just a few comments, expressions to make. Needless to say, we are very relieved to be exonerated. I think we all just found out here recently that you can just be going along your merry way doing your job and not bothering anyone and come under attack and end up dead. The reason that we took the very aggressive approach that we did is because the very livelihood of our business and the very legacy of our family name and all those people associated with us was at stake. If we offended anyone here by our approach, my wife told me I pointed fingers. Mr. Manius and staff, commissioners and judge, we didn't intend to. Again, I would like to commend the staff on a job well done. We found ourselves in limbo when we started getting a number of phone calls several weeks back about this issue. We felt like we had to step up and speak the truth. We had experienced a situation several years back where the media told only half the story. And as a result of that experience and the cost and pain of not having the whole story told, being experienced, we felt like we had to step up. I appreciate you all for taking time to hear us. Judge, I don't know if there's any time limit on speaking, but I'm sure I overtalk my time. But that said, I just wanted to share with you the impact of allegations being brought like this. I have employees at my main office here, and thank God I'm able to say I have a number of employees at DFW Airport. Those employees have been concerned about whether or not their boss, the guy who signs their paycheck, was going to end up in jail and they would be without a job. I have a couple of office buildings on South Freeway. The vending machine man that puts the chips in the machine was concerned, are you going to possibly go to jail? As I shared with you before, my wife and my 10-year-old son and my 5-year-old daughter were concerned. Is Daddy going to be here with us to take care of us? I felt like I had to step up without delay and bring truth and facts into the discussion. I appreciate you all for hearing me. I appreciate the audience for hearing me. I need to ask you all's help in one more thing. Because when the Star-Telegram or any other media outlet goes out and prints inaccurate and untrue or partial information on the front page and then corrects it on page 50 at the bottom, it leaves the impression among many readers and many who hear the news, false information. I need to appeal upon you, particularly elected officials who wield a lot of influence. And I do appreciate you, Commissioner Brooks, for pointing out the particular sentence that says there was no wrongdoing by R.D. Howard. I appreciate that. But I need you all and each one of you all to go forward and help tell the truth. Because otherwise, there will be people out there who never got the whole story, or who heard, and by the time it was told the 10th time, it was all kinds of misinformation. There will be calls that we never got from customers we never knew we likely had by misinformation and incorrect statements. We dealt with that 15 years ago regarding the Bass Hall sidewalks. We couldn't afford to do it again. I also have a problem. I've always been brought up to think that in the United States of America, the greatest country on earth, you would be able to face your accuser. It is insulting to me and offensive to me that somebody could tell lies on me and be shielded and shadowed from public view. And yet my name, my reputation, and that of my company be broadcast for everybody to see. There's something inherently wrong with that, and that needs to be addressed. I understand and value. I'm a taxpayer here in Tarrant County, have been here all my life, except for the 4 years I was away in college. I value the need for accountability. I value the need for any government government agency, a body, to be able to investigate allegations. I appreciate that. But there's something wrong with the system. My dad used to call it throwing a rock and hiding your hand. There needs to be some accountability. That person needs to be brought up on charges, because that information, as it related to me and my company, was absolutely false. I'm going to close and take my seat. I appreciate you all. I appreciate the support from my family, my employees, my church, everybody who believed in me. I heard from people I hadn't talked to and seen since elementary school. I heard from people from college, from Colorado, from San Antonio. I heard from people all over this county and the city supporting me and saying, Randall, we couldn't believe it. We know you better than that. I appreciate those people for supporting me. I appreciate my family, my wife, for watching me march and prance the floor at night and wrestle with this and see if I can bring truth into this discussion. So I just want to say thank you. I thank you. Y'all need to make sure the word is told as loudly with truth as it has been with the lies.
Mr. Howard, thank you very much for coming here today, and we're glad that we've got this behind us. So thank you very much. With that, we will recess our open meeting and proceed to closed session to discuss items exempted under Section 551.